Hello and good afternoon or morning, depending on where you are. My name is Ryan Conlon, and joining me this morning is my friend and partner Jeremy Schwartz to give you the latest on the world of vaccine mandates. I joked on the last webinar that this will probably be the last webinar on COVID. Yeah, famous last words. The case law is coming out fast and furious on vaccine mandates. We literally have some cases we're going to be talking about that were literally decided just a couple of days ago. So the window is becoming a little more clear as to what direction that courts and arbitrators are taking with these kind of issues that remain fairly controversial in the country. So where we're going to sort of walk through, we're going to take a look at first at sort of an update of some statistics from the end of last month about sort of where we're at with vaccination rates and such. And then from there, we're going to spend a fair bit of time talking about some of the latest cases, a couple of decisions from labor arbitrators, a couple of decisions from the courts. I mean, these are by no means all of the decisions on the subjects. There's some others that are out there, but these are the major ones that are relevant to employers in Ontario. We're also going to take a look at how the Joint Health and Safety Committee fits into these issues. We're going to take a brief look at what's going on south of the border. I know a lot of you are either owned by or routinely interact with American management, so I thought it'd be useful for you to get a sense as to what, at a very high level, what is going on in the United States as far as vaccine mandates are concerned. And then Jeremy and I are going to peer into our crystal ball, give you a few comments about where we think this is going. I mean, it's just when you think it's over, obviously there's been a considerable amount of attention paid to the latest Omicron variant, which has resulted in certainly a resumption of more restrictive rules at the border, including a new quarantine requirement for people that are coming in from countries other than the United States, and outright travel bans for a number of African nations. So, I mean, just as we thought we were heading into progress, perhaps certainly are seeing, in terms of at least a risk management front, things getting to be tightening up yet again. All right, so let's take a look at where we're at with where we're at with vaccines. And on a global perspective, Canada is doing quite well from the perspective of having citizens vaccinated. We have almost 90% of citizens. These statistics are accurate to sort of to the middle of late last month. It might be slightly higher now. So we have 80% of the total population has one dose. 90% of those 12 years and older, almost 90%. Obviously, a very small number of the 5 to 11-year-old population set. Full vaccination is, 86.42%, of the population 12 and older. And you're looking at, obviously a very small percentage of those who are at the 5 to 11 level. So, I mean, when you compare those numbers to vaccine levels in the United States, it's significantly higher. And these are fairly consistent numbers across the country, really. Ontario sits right in the middle at about 78% of people who've cumulatively received one dose of the entire population. So, I mean, as you're seeing, basically the numbers are high 70, around 80%. So these are from the perspective of the spread of, to hasten the spread of serious complications coming from COVID-19. These are positive numbers. And this is a very interesting slide. I mean, this is the percentage of of COVID cases between those who are ended up hospitalized and such, for those that are fully vaccinated, for those who are not. And look, I mean, I think the numbers are pretty straightforward and obvious. I mean, the percentage of confirmed COVID cases are 80% people who are unvaccinated, and then maybe 5%. So, and then the number for number of those that are fully vaccinated, somewhere in the neighborhood of 8%. Look at those who are hospitalized, again, 6% are people that are fully vaccinated, 8%, and 3/4 of all deaths are people that are not vaccinated. So, I mean, look, this is not a political program or any of those things. I can only speak to what the stats seem to show, that there appears to be overwhelming, frankly, evidence of the benefit of vaccination as it currently stands, and how that relates to Omicron is a different question. But these would be the kind of figures that a court would look at. And I think that a court looking at these numbers would have, or an arbitrator has virtually make it beyond debate about the benefits of vaccination. So bear that in mind when you're looking, regardless of where one's views fall on these things. Where are you at? It's interesting as to sort of like the notion that there were going to be restrictions on individuals for vaccinations is something that was, certainly well on the government's radar almost exactly a year ago, when Christine Elliott, who's then and now is the provincial minister of health in Ontario, said there may be some restrictions placed on people that don't have vaccines for travel purposes to be able to go to theaters and other places. That will be up to the individual person to decide what they want to receive the vaccine to be able to do these things or not. So, I mean, the concept of a vaccine passport has always been on the radar since the vaccines were in development and long before they were distributed on a mass scale in Canada, where that largely started sort of in the middle of this year. So that's where we're at. I should also tell you, as we get into the more substantive part of the content, we will be leaving some time for questions. So for those of you who want to, ask some questions to us, we're looking forward to answering those as time permits. So then we'll go to the next slide. I'm going to turn it over now to Jeremy Schwartz. He's going to speak to you about sort of the case law as it develops on these issues, starting with one of the early a vaccine case that has been cited many times in relation to the flu vaccine.
Thanks, Ryan. So yeah, I'm playing a dual role here. I'm also sort of moderating the question and the slide part of the presentation in our platform. So I noticed there was one question from someone who said they could not see the slides, but from all IT related aspects, it does appear that they're working fine. So for the individual or individuals who are having difficulty either hearing or seeing, my best suggestion, I think, at this point would be to close and then reopen the webinar platform, and then you should be okay. Check your settings that way. So this is a case that is from 2018, and it does not deal with COVID. Okay, so this is a case from St. Michael's Hospital. This is a case that is generally cited in the arbitrations and other decisions which relate to policies on the requirement to vaccinate or take other precautions. And unfortunately, it was a case that ruled against the employer, and also unfortunate, this analysis from this case is the predominant analysis pre-COVID on what happens when an employer wants to have a vaccination policy for certain groups of employees. And there were some cases in 2013 in BC. There were some earlier cases during the SARS epidemic in early 2000. But this case from 2018 really is the pre-pandemic exemplar of how arbitrators and courts view the situation when it comes to an employer imposing a policy on a group of workers within a workplace and the analysis that they're going to apply. And so again, this is pre-COVID, but let's look at what the arbitrator in this case determined. So what we have is the union grieves that a vaccinate or mask policy, so this wasn't even a vaccinate or test or a vaccinate or off on a leave of absence until you vaccinate or even get fired for cause policy. And the arbitrator found there was insufficient evidence in that case that masking was an effective precaution. And so they couldn't impose a policy that said if you're not vaccinated, you have to mask. And so these are folks who could have gotten the flu shot, who elected not to get one, not for human rights related reasons. Simply, I don't want to put that foreign substance into my body and you can't make me, employer. And the employer was saying, well, under our policy, if you don't vaccinate, you have to mask. And if you don't do either, you'll be placed off on a unpaid leave of absence until the influenza outbreak season really is over. That's essentially what happened. And the arbitrator said, you've not presented enough evidence that masking would be an effective alternative. So you can't have this zero-sum game of vaccinate or mask. And one of the significant evidentiary problems the employer had was there were groups of people in the public who could come to the hospital and go into the same areas where the same vulnerable patients were being treated, and they didn't have to mask or take other precautions in those circumstances. And so to require the staff member in the same circumstances to vaccinate or mask, but not have a similar requirement for people who are coming into the space, basically took away the entire substrata of the employer's argument here. And so not surprisingly, the arbitrator said, you can't force these options on someone without the evidence to back it up. Now, this is obviously distinguishable from the COVID-19 pandemic. Almost immediately, there were rules about accessing facilities where there were vulnerable people, whether that be long-term care facilities or whether that be facilities like hospitals or similar circumstances where there are vulnerable patients or members of the public who might be exposed. And so whether you're a member of the public or you're a member of staff, there are restrictions during COVID that I don't think were in play at St. Michael's in that hospital in that case that we have from 2018. So fast forward to November of 2021, a decision by an arbitrator dealing with Paragon Protection Limited. This was the UFCW brought a grievance alleging that an employer policy that required all of the guards to vaccinate so that there weren't going to be any issues dispatching them to work or assigning them to work at various client sites, whether that policy violated the collective agreement and or the human rights code. And so one thing that, as I take you through this and another arbitration case, that you need to keep in mind is, for those of you who deal with collective agreements, who have them for your workers, you'll be familiar with this principle. But for everyone else, these cases have to be analyzed through the lens of a labor arbitration and the jurisprudence and the applicable case law and legislation that applies when you're dealing with a unionized workforce. So unlike in a civil dispute or a human rights tribunal application, you're not just dealing with the human rights code. And the question of whether the policy is enforceable, is lawful, isn't just a question of fundamental justice or the human rights code or rights of privacy. It actually is more fundamental to the labor relations scheme itself. And so you go back to a case called KVP, and KVP is from decades ago, but essentially there are a number of parts to the KVP test that come out of that. And in general, when applying this test, in almost all cases, the decision of the arbitrator comes down to the prong of the test that deals with whether it's reasonable. So you can't implement a policy, for example, under the KVP test that is in direct contravention to something that's in the collective agreement. So if you've got a collective agreement that says you can't have this policy, then you can't implement one without violating the collective agreement. KVP says that's one of the tests. But most employers don't try to implement a policy that is in direct, explicit contravention of their collective agreement. Instead, they're exercising what would be called management rights. Management rights is what we call them in a unionized setting. Outside of the unionized setting, it's really just the employer's right and obligation to manage the workplace in all ways, whether from a health and safety perspective as an obligation, or whether in general as the employer of the workplace to set down policies and rules about how work will be conducted and how people are going to interact. So in this case, we have nearly 5,000 security guards at 450 client sites or more. And interestingly, 5 years earlier, the parties agreed, I guess they saw it coming, they had a better crystal ball than the rest of us, it would have been nice to have a heads up, they put in their collective agreement that if a client site, if a customer says you've got to inoculate or you can't assign that staff person to our site, then that was baked into their collective agreement already from 5 years ago. And so in a lead up near the end of this year, sort of in the fall, August, September of this year, they got a number of notices from clients, probably because of the chief medical officer of health in local jurisdictions or the Ontario regulation that got updated, who started to tell them, we're going to be putting in place a policy that will require not only our staff, but all visiting third-party service providers to ensure that their folks provide proof of vaccination subject to human rights. And so Paragon said, okay, we're going to have to implement a policy that requires mandatory vaccination, and the union grieved. Now, in this case, the arbitrator found, and unfortunately there isn't a significant amount of analysis in the case, but there are some helpful nuggets that we can take out of the decision. So first, the arbitrator finds that receiving the COVID vaccine is voluntary. So it's the consequences, so it's choosing not to vaccinate, is a voluntary choice. And the consequences of this are you bring a grievance and you assert that you have been terminated without cause or that you've been disadvantaged without just cause. And then you can grieve individually for remediation. And he also found that the personal subjective perceptions of employees, people who would express fear about vaccination or having to deal in particular with symptoms that people may experience following vaccination. We've all heard that from certain vaccines, certain individuals may have quite substantial symptoms that arise. They don't actually get COVID, but they might get symptoms that are similar to a difficult flu virus from getting the vaccine itself. And of course, allergic reactions that were unanticipated or that they didn't know were going to occur if perhaps they hadn't been vaccinated before. But the arbitrator says, subject to the Human Rights Code, which is another issue altogether, which was addressed in the policy, we're not going to let employees' individual preferences and perspectives take away the obligation for them to comply with the policy. The arbitrator also found as fact that this policy, that implementing this policy was an example, was a form of the employer complying with its duties under the Health and Safety Act, the general duty, of course, under 25(2)H, to take every precaution reasonable in the circumstances. Now, it's a bit of a sort of a figure eight here. You know, they use the precaution reasonable in the circumstances, and so they're taking a precaution that's reasonable because it's a precaution that's reasonable. So a bit cyclical there in the reasoning, but the arbitrator did find as fact that this was a precaution that was a reasonable one in the circumstances from a health and safety perspective. So I think looking at the evidence and looking at the actions of the parties, the arbitrator was willing to find not just under the collective agreement or human rights jurisprudence, but under health and safety law, this was a reasonable precaution. And finally, the arbitrator said the policy is reasonable in that KVP perspective, following the test, in that it struck a balance between the affected employees and other staff and the client locations and public of the customer sites. Now, this case, as nice as those nuggets are, I'm not aware of any other case where an arbitrator has gone that far. And I would also point out that it's unique in two aspects. First and foremost, the parties already had a policy from 5 years ago baked into their collective agreement where the employees had already agreed, or their union did on their behalf, that they would be required to be or could be required to be inoculated when a client site requires inoculation. So unfortunately, the employees already agreed before they knew this was a thing. And then it became a thing, and they had already essentially agreed. So it wasn't hard for the arbitrator to find. It was reasonable on the KVP test when very similar language had already been agreed by the parties in free collective negotiations 5 years previous in their collective agreement. And finally, this is also distinct or unique because these employees are in general the guards who are going out to third-party locations. So it is still black letter law under labor relations in arbitration or interpretation of collective agreements that if you can't send someone to work at a third-party site because of the rules of that third party, then you as an employer, there's nothing you can do about that. So the result might be that that individual was laid off for lack of work, or it may be that they have recall or bumping rights under the collective agreement, but it's not a just cause termination. It's not a just cause demotion or a just cause layoff. It's simply, we don't have work for them over at that client site. So this was a unique situation for a number of reasons. So I don't want anyone to think that this decision should be taken as a free pass to go ahead and implement a similar policy for employees, whether unionized or not unionized. And that sentiment that I'm trying to sort of press a little bit here really comes out of the case, which came out almost within 2 weeks of the last Electrical Safety Authority and Power Workers Union. So the Power Workers Union had actually supported the employer's policy, which was initially adopted, a vaccinate or test policy. And that is the same sort of policy that chief medical officers of health have been recommending. That's the same sort of policy that became a requirement through that regulatory change. If you came up and joined us for our last webinars from September 24th and on, you would have heard us talk about the regulation, which in Ontario required all employers to comply with the recommendations, advice, and directions of the chief medical officer of health in their local geographic area, which in certain parts of Ontario expressly required employers to put in place a policy. And that policy would be essentially vaccinate or test policy. And So a lot of employers are putting those in place. Everyone instinctively can see that getting tested if you're not vaccinated, there's some logic there. It makes a little bit of sense. Arguably, that may not make as much sense if we look at the actual technical evidence that has come out about the fallibility of testing. And I'll talk a little bit about that. But it does appear that a lot of employers, including the Electrical Safety Authority, came out with these sorts of policies, and unions have been, at least anecdotally and in arbitration decisions that I've seen, have been supporting those as opposed to the truncheon approach of a vaccinate or you're off on a leave or fired policy. So I guess if they're forced to choose between one or the other, they prefer the vaccinate or test policy. At some point in the late fall, the employer pivots, says we're going to have a mandatory vaccination policy, and anyone who doesn't vaccinate essentially is off on an unpaid leave of absence or is terminated from employment. And there were really no significant changes in the circumstances, at least evidentially. So the employer didn't lead any evidence that the vaccinate or test policy was creating a hardship. They didn't lead any evidence that they were having a significant number of people test positive for COVID and through the vaccinate or test paradigm, so that there was a justification to imposing a more significant policy that required vaccination as a mandatory step. They just went ahead and did it. And so the arbitrator acknowledged that testing is fallible, that we don't always, in rapid testing, we don't always get the results right away. There might be false positives, there might be false negatives. It may take longer, especially for asymptomatic people, to test positive for COVID. So that means that there are people who are carriers of the virus who may be active and circulating in the employee and public population in the workplace. And unfortunately, the arbitrator said, but there was no evidence of a particular workplace concern. This wasn't a situation where we have a substantially vulnerable public. We're not dealing with a long-term care home. We're not dealing with a hospital. We're not dealing with situations of community living. And so applying the KVP test, although it wasn't a violation necessarily of anything expressed in the collective agreement, although it wasn't necessarily a violation of human rights or the health and safety entitlements or requirements of the employer, nothing is expressed there. It wasn't reasonable for the employer to shift from a vaccinate or test policy on one side to a vaccinate or test policy to a vaccinate only policy. And so I have to say, unfortunately, the employer here failed to lead evidence which might be available, right? So there is evidence now that although the testing is useful, that there are issues with the tests. Although the people at the ESA were going out to client locations, and in some cases inspectors might go to people's homes, they couldn't lead any evidence that people were getting turned away from client sites. One would expect that at some point that evidence will be available and maybe they'll try this again. But in the meantime, they didn't have that evidence to demonstrate, or at least they didn't mount that evidence for the arbitrator's benefit. So now I'll turn this over to Ryan to talk about how the courts are reacting. Ryan?
All right, thanks, Jeremy. We're good. So here's the thing. The bottom line is we need to kind of look at this from the perspective of what the law has been historically on labor relations in the courts. A policy decision was made decades ago that the disputes between unionized employers and the union members, the bargaining unit members, would be dealt with by means of proceedings at the Labor Relations Board, or more commonly before a grievance arbitrator appointed under the collective agreement, which in Ontario and most other places is a mandatory situation under labor relations law. Courts have very limited roles in labor relations disputes. They are sometimes called upon to issue injunctions in the context of picketing and strikes. They will hear judicial review applications from decisions of arbitrators and such, so basically not an appeal, but sort of a limited review on jurisdiction and other legal grounds. At the start of the pandemic, one big sort of asterisk, there was a case out of Ontario called Participating Hospitals, which dealt with these very early in the pandemic, dealing with sort of the sufficiency of personal protective equipment back at a time when there was significant shortages of masks and such. And ultimately, the Superior Court did intervene and grant an application and decision that surprised a number of us, because it certainly was a departure from the general principle that this is something an arbitrator should be dealing with, not a superior court by way of an injunction. And then just made us think, well, are we entering a world now where all of a sudden the courts are going to depart from their historic and usual practice of not being involved at first instance in labor relations dispute, and start issuing direct injunctions and orders around things like personal protective equipment and other matters that fall squarely under the collective agreement and the labor legislation that an arbitrator has the legal power to interpret. Well, the participating hospitals case has seemed to be an outlier. Certainly with vaccine mandates, a couple of unions have tried to come in and address these issues. And the first case I want to talk about is the Wajdan v. Attorney General Canada case. This is a bunch of non-union federal employees, so this isn't strictly a union case, but it is cases where these employees have access to the fairly comprehensive grievance and dispute resolution provisions under the Canada Labor Code. And basically, these employees tried to get out of the court's traditional position on labor relations disputes, employee relations disputes, by saying, hey, this is a case, what the government's really doing here, this is part of an agenda to force people to get vaccinated. This really isn't a labor relations dispute, it's part of a broader policy mandate. And look, I mean, it's probably some merit. There's no doubt that the government of Canada wants people to get vaccinated. They've been pretty clear about that. But the judge found, look, there's no evidence whatsoever that this specific move to dealing with these specific group of employees had anything to do with some broader policy agenda, and everything to do with the type of dispute that arises in the labor relations context. And basically, the court just rejected it and pretty categorically said, look, we're not going to intervene in this dispute. So from that perspective, the courts have basically said, without even adjudicating the merits of these cases, to say, if you want to argue this case, you got to do it before an arbitrator. You'll get on to the next slide. And before we get it, so basically, I mean, that really is and really does kind of sum up what the courts have done in these cases, involving the TTC, a very similar outcome that just basically, again, is saying we're not hearing this dispute. That look, the bottom line is, like, one of the arguments that has been made where an application was made in the context of the subway system in Toronto on behalf of those employees was that there was a harm there was an issue that basically said, look, you have to go to court because there's no way it would be irreparable harm for if the matter wasn't resolved by the court. The court said, well, that's nonsense. I mean, labor relations disputes are resolved with money. If an employee is fired wrongly, they're entitled to back pay under arbitration in most circumstances. So look, if ultimately an arbitrator were to rule that these vaccine mandates offended the collective agreement or other legislation, then ultimately the remedy would be financial, and that's what it is almost always in labor relations cases. So what does that tell us? What it tells us is that in the unionized context, courts aren't going to touch these things. It doesn't seem. It's not surprising. I mean, there was a very recent decision of the Supreme Court of Canada which reiterated that even human rights disputes, which are obviously quite relevant to COVID, because there are certain, obviously there are sort of religious grounds and disability grounds potentially that are triggered. I mean, even then they said, look, if it's a human rights dispute in the unionized context, it's going to be resolved by an arbitrator, reaffirming the commitment that the court made in almost 30 years ago in the Weber versus Hydro case that these disputes are going to be dealt with by arbitrators. And what's the practical impact of that? Well, the practical impact of that is it's probably going to take employees longer to get an outcome, because an interlocutory injunction is something that can be obtained fairly quickly. Arbitration decisions depend on availability of arbitrators, and are not necessarily a particularly simple process in some cases. I mean, then how arbitration works, who's arbitrating the case, and how complicated it is something that very much depends upon the terms of the individual collective agreement and the individual private arbitrator who's been chosen. So what about the Joint Health and Safety Committee? What role do they have in these issues? And the power workers case that was discussed earlier is helpful in this context, and where that goes is it just as a reminder to us that basically the Occupational Health and Safety Act, Section 918B, says that the committee has the power to make recommendations to the employer for making improvements to health and safety. It is in an employer's interest to make sure that the employer member of the committee, brings forward and seeks input from the Joint Health and Safety Committee on this issue. And you know what? And I can just hear the cringing and some people in the audience recognizing that this means that, you may get, if you have a committee member that feels particularly strongly against vaccine mandates, or even a committee that's entirely against them, that you're going to be seeing literature dealing with the Nuremberg conventions and all kinds of other things. Bottom line is that these recommendations are binding. You have to listen to them. You have to consider them. And careful consideration should be given to credible recommendations from the Joint Health and Safety Committee. They may be looking at it from outside the box, may be able to give you some ideas that maybe there are some circumstances where some alternatives to a strict vaccine mandate may make sense in certain instances. Or quite frankly, on the other side, you may have certain committee members who don't think the employer is going far enough and that the mandate should be stricter, and this is why. All those things should be considered. As in the Power Worker Union case, the arbitrator pointed out, one of the things that didn't happen in that case is it wasn't dealt with through the Joint Health and Safety Committee. So it is something that should be canvassed with the committee, but remembering that the recommendations of the committee are just that, recommendations. And some of them, those recommendations may be quite helpful, and some of them may not be. So I'm going to turn it back over to Jeremy, who's going to get into the drug and alcohol issues and how these compare to COVID type vaccine issues.
Thanks, Ryan. So one of the things that people often get upset about is when we talk about testing, we immediately think as employers pre-COVID, testing for things like drug and alcohol. And the case law is thankfully very different when it comes to how courts, all the way up to the Supreme Court of Canada and arbitrators and the Human Rights Tribunal, deal with testing from a drug and alcohol perspective, and how they deal with it when it comes to COVID testing. So just to give you a very high level, essentially there is no legislation that deals explicitly with workplace drug and alcohol testing. So similarly, until the regulations, for example, in Ontario that deal with the recommendations of the Chief Medical Officer of Health, recommending a vaccinate or test policy, for example, there was no legislation that dealt with the workplace aspect of whether someone has to vaccinate or get tested. And so until that point, employers were sort of left out there wondering. They might be working in a restaurant where they have to ensure that patrons are vaccinated and show their proof of vaccination through their passports or some other means, and yet the staff who are serving the patrons didn't have any express legislation that said what they had to do. And so to a certain extent, that remains the case, and it boggles my mind that that's okay, but that's what our provincial government and some others have done. And again, I don't want to get into the politics of this. I'm speaking only from the scientific perspective. If the science desk says this is the way to go, then perhaps that's how it should go for all. But in any event, what we've got here is an absence of legislation. And then we have a general duty. And in the case of drug and alcohol, there have not been any cases which have said that an employer that, for example, fails to have mandatory drug and alcohol testing, whether it be random or post-incident, is in some way violating the 25(2)H general duty clause or any explicit obligations in any regulations on ensuring the health and safety of the employees in the workplace. Contrast that, of course, with COVID, where we have an arbitrator in the first case that I took you to, which expressly found in that decision that it was a form of reasonable precaution in the circumstances for the employer to do that. Now, we didn't have a case where an arbitrator or a court or a tribunal was saying that an employer that failed to implement a mandatory vaccination policy and therefore failed to take all precautions reasonable in the circumstances. But I think an argument can be made that some policy, whether that be a vaccinate or test or a vaccinate or mask policy, may actually be a reasonable precaution that's necessary, and failing to have at least one of those may actually be a violation of the Health and Safety Act. And we haven't seen prosecutions of that sort yet, and maybe we never will, and hopefully there won't be any significant situations where the Ministry of Labor goes in and says, well, you've basically taken no precautions, and so we're going to charge you with everything and see what sticks. But I think arguably having a policy that either requires one or the other of those things is a form of reasonable precaution that may be a requirement under health and safety law. But again, in drug and alcohol testing, the general duty clause has not been seen as granting a license to employers for random drug and alcohol screening. Courts and arbitrators have historically restricted the right of employers to implement these programs for that reason, and in large part they've adopted the opponent's perspective, which is that these are violations of human rights or the sanctity of the person or whatever. I have my own thoughts on this. I think it's ludicrous. This isn't a case on drug and alcohol testing, or I can get more into it. We just don't have time for that today. But essentially, the courts, all the way up to the Supreme Court of Canada, have said you must have evidence of a problem before you can implement any form of random drug and alcohol testing, and that evidence is not presumed to exist. So contrast that with the situation in COVID. So this is a case in Nevada Foods where there was, this is early days in COVID, where a food processing plant was essentially relying on the evidence scientifically that they had established from before, which demonstrated, I apologize, my phone is ringing. I don't know how to turn the damn thing off. I turned off my cell phone, but not my COVID basement general house line. Sorry for that. So in this particular case, Labor Board said we're going to follow what's called the precautionary principle. We're going to take the position that the science says, or the science appears to be showing, again, this was early days, that masking is better than face shields and trying to socially distance. And so even though there was evidence that the employer had led in that case, that employees might touch their mask or they might do other things, and so masking may actually enhance other forms of risk, not necessarily COVID risk, the Labor Board said, but the regulation makes it clear you have to put a mask on, and in the circumstances based on the order, the employer refused, and that was a violation. And the board was going to uphold that direction, that instruction, that order from the Ministry of Labor Inspector that all the folks at this food processing plant would be masked in order to abate some of that risk. And I would suggest that a very similar approach is being used in COVID times with respect to the question of whether you have a vaccinate only policy over here, or at least a vaccinate or test policy. So although, as in the ESA case, there is evidence that there's a fallibility to the testing aspect of it. And although there is some discomfort to being required to go through a test, the rapid testing is actually far less invasive, of course, than a PCR test. PCR tests are generally not done unless a rapid test comes back positive, showing that there may be an infection, in which case you go for a PCR test. And so it would seem that arbitrators and courts are leaning in that direction. So what have we got? It's fact specific, whether you're going to get away with having a vaccinate only policy, and it would seem courts and arbitrators are leaning in that direction only where there's something specific in the contract that allows for it anyways, as we saw in the first case, or where there are special vulnerable population or folks in the workplace themselves where really the efficacy of vaccinating is going to have that significantly marked impact on abating those risk factors. Again, scientifically, I'm not sure that's sustainable. Ryan shared the statistics. We have 3/4 of the people who are dying from COVID are the people who are unvaccinated, and whether they're testing or not really isn't going to save their lives, because as the evidence scientifically has shown, just because you're vaccinated doesn't mean you're not a carrier. So you could be vaccinated, you could give it to someone else. If that individual is unvaccinated and all they're doing is wearing a mask and getting tested once in a while, the test is just going to show them that they got COVID. But it's not going to defend them against the serious and possibly deadly side effects that may develop because they're an unvaccinated person who just got COVID. So again, the science, in my view, does not bear out this analysis or the logic of this trade-off. But I have to say, it would seem courts and arbitrators are leaning to the middle, or at least what they view as the middle, which is a vaccinate or test policy is generally going to be viewed as reasonable, and a vaccinate or nothing policy in general is not being adopted as a reasonable measure or as a mandatory or seemingly mandatory exercise of the employer's obligations to meet those health and safety requirements under 25(2)H, the general duty clause. So for better or for worse, it would appear that in many circumstances, absent a legislative framework that requires it, or a particularly vulnerable or a situation of enhanced risk for some reason in the population that you're either serving in the public or in your workforce, a vaccinate or test policy is 95% likely to succeed. If it's challenged, it will be upheld in many circumstances or most circumstances. And getting a vaccinate only, a mandatory vaccination policy where you're put off on leave or remote working if it's feasible and reasonable policy is much less likely to succeed, except in those unique and special circumstances. I have to say I don't agree with that. I have to say, again, the science doesn't support it, but that does seem to be where we're at. Ryan?
Okay, so we're just shifting quickly. I mentioned that we talked about what's going on in the U.S., and some of you who follow American news and politics would have heard of this before. So down in the U.S., basically, President Biden, a Democrat, as most of you know, has attempted to impose a national vaccine mandate for private employers with 100 or more employees through executive action. Which that basically means is rather than go through the congressional process, which is a very fraught and complicated process involving basically getting it through the House of Representatives and getting 60 senators to vote in the Senate, which is, I mean, very little 60 senators agree on anything in the U.S. So basically what the president's tried to do is to use the OSHA statute, which is the Occupational Health and Safety Administration Act in the United States, to push through a vaccine mandate that applies to employers under the rulemaking powers. These efforts have been halted in the courts. There was a fair degree of skepticism, I can say, having talked to, our firm is a part of a network of firms called Work Law. We was at a conference recently with those lawyers, and a number of them expressed some quite a bit of skepticism as to whether that mandate would be legally permitted, and their views turned out to be prescient. The effort has been halted in various federal courts across the United States. So basically, the vaccine mandate has stalled in the U.S. Largely, again, much like in Canada with the labor cases, it's really on jurisdictional grounds, primarily saying the president doesn't have the power to unilaterally use the OSHA statute to push this through. There's also another practical problem, I think, that with the vaccine mandate is in some places in the United States, the vaccine rate is astonishingly low compared to Canada. And in those cases, if one really did impose a widespread vaccine mandate, you wouldn't have any employees, including the very sensitive healthcare sector. So there is just the reality is you just do not have the vaccine uptake in the US that you do in Canada. So really, at the end of the day, whether or not the president has the power to implement a vaccine mandate, I'm hoping that by the time anyone makes that decision, it'll probably be a moot point. But at this point, I think you can say, but I think that if you're talking the practical point for the United States versus Canada, if you're talking to your American colleagues or Americans who are directing human resources in Canada, they got to understand it's sort of a different world here. Unlike in the US, basically there is widespread support for some type of vaccine mandate, not necessarily a strict one, but just Jeremy said, certainly either a vaccine mandate or testing is something that's legally well grounded in Canada. And certainly the numbers of the unvaccinated, well, certainly are much lower than in the United States. So it's a very different situation legally and practically in those circumstances. Lastly, just that's going to give you sort of we said we'd give you a crystal ball looking ahead as to where this is going, and that's a hard thing to do. We don't know, obviously, at this stage whether the Omicron variant, which has considerably heightened concern, but no clear answers as to whether or not it will join the Mu variant and other variants that we've heard about as not being much different, or it'll be more like Delta, which was a game changer in some of the waves of COVID that affected Canada, including particularly and to see how it responds to vaccines as places where it originated, of course, did not have, unfortunately, significant levels of vaccination. So basically, what we're basically telling you is I think that when you're dealing with employees, you've got to get away from the politics on this. Like a trip to Facebook is an interesting place when it comes to all the views on this. We're not getting into political and legal debates. What we do know is that as it stands now, Canadian employers Ontario employers are well grounded in having vaccine mandates that include either a vaccination requirement or having a testing regime. That human rights exemptions religious exemptions are particularly uncommon, as we've discussed in early seminars. Don't let the fear of litigation prevent you from doing something. It's a legal mandate at the local health authority level to deal with these things, so we think it's an important idea. Privacy. I mean, remember the privacy rights have to be respected, and you just want to make sure you follow that. The information you get from employees and their vaccine status is healthcare information, and it's not to be disseminated widely. I mean, reality is if you require unvaccinated employees to take certain precautions, privacy may be a bit of a ephemeral notional figure rather than a practical, realistic one, but those laws exist. And lastly, I think Jeremy's point is context. Basically, it's a very workplace-specific situation. So an office where you can be socially distanced versus a healthcare facility that admits COVID patients are two very different places. and may require practically two very different responses. And so I think really it's to avoid the politics and get right into the the merits of all this. So I mean, without further ado, I think we're at about 1:45 now. So we'd like to see if there are any questions, Jeremy. I guess we can get into those.
Thanks, Ryan. So we do have a couple of questions here. So maybe this is a good one for you because it sort of ties off from something you said a moment ago about sort of the human rights aspect of some of this. And again, this was covered in earlier programs. So this question is, what about those who say that their reason is for creed, they don't want to be vaccinated, and now after being terminated for cause, say that it was discrimination and their quote unquote disability was not considered. So this is sort of a practical question, I gather. It's someone who changes their reasons post termination and tries to assert that in some way you violated the code. What are your thoughts about that, Ryan?
Well, here's a couple of things. Like the human rights area in this area, first of all, I mean, we know that from the College of Physicians and Surgeons in Ontario, that legitimate reasons to not be vaccinated on the basis of disability are few and far between. You're not quite in winning the Lotto 649 territory, but you're close in terms of how small percentages of the population legitimate medical conditions. So someone who's trying to assert that is probably in for a very difficult evidential battle, even without the practical problem that they have, that they were asserting creed previously, and creed is the human rights code term for religion or set of spiritual beliefs. So I think on those facts, I think it's that's probably going to be a extremely difficult case for that employee to litigate. They wanted to raise a disability issue, they should have, and then even if one were to assume that the employer should sort of post termination consider that issue, which probably wouldn't be a bad idea. At the end of the day, they have to prove they have a disability, and they have to get a doctor to get up there and testify to that. And we know that the College of Physicians and Surgeons has made it pretty clear to doctors they can't just write random exemption notes. So I would say that I would rather have the company's case than the employee's case on those facts.
I would agree. A question, I think I'll take this one. Someone has asked if we can provide a little bit more on the way that the law we've been discussing would apply for non-unionized employees. So I think on a couple of points, in respect to the arbitrations that I referenced at the bottom, although those two decisions were based in the collective agreement labor relations world, and so that was an important point that I was making, the analysis that the arbitrators applied, the way in which the employer was exercising its duties under the Health and Safety Act, and their, in the labor relations sense, management rights, in the employment sense, their employer's rights, very similar. And the test that comes out of the Supreme Court of Canada and other various decisions in wrongful dismissal litigation, for example, is very similar. If the employer sets out a policy and the employee violates that policy or rule, and the consequence to the employee is what would be in a non-unionized sector, either a constructive dismissal or an actual dismissal, then the question will be, did they violate the employment contract? And so if it's an implied employee obligation to follow the employer's lawful policies, including health and safety COVID-related policies, and if that policy is reasonable and lawful in the circumstances, then it might be just cause. It might be cause at common law for that employee to refuse or fail to follow that policy. So again, we're not talking about unionized folks, we're talking about non-unionized folks. The one practical difference here, and why it may take some time for these cases to filter through, is that an arbitrator can hear a case, you get a grievance, it can get referred to arbitration, it can go through expedited arbitration, you can have a decision in 30 days. Whereas a wrongful dismissal action, especially these days electronically and all the processes that have to go through, could take 6 months, a year, or longer before we see a court decision on whether it was a constructive dismissal for an employer to implement a vaccinate or test or a vaccinate or you're out policy. So as much as I think the legal analysis is very similar, it's going to take some more time, I think, before we see any of those cases really hit the road there. Ryan, do you have any other comments in that respect, maybe in terms of the court process aspect of what you discussed?
Yeah, I mean, I guess the only thing that I could say is the bottom. Unfortunately, look, the courts are still very, very, very jammed with cases that predated the pandemic. I mean, the regular court schedules are still not. Courts in particular have been as quick on the uptick as tribunals have been with moving hearings virtually and such. A lot of things are still pending out there. So realistically, when you're actually going to get legal guidance from the courts, I'm hoping the pandemic will finally be over in most cases. You may get the odd summary judgment decision, I guess, but. I think that really when you're looking at common sense, really, you want to think long and hard about terminating someone for cause in many instances if, a leave of absence would be an appropriate alternative. But, that's not going to be the case everywhere. And it's like, our bottom line reality is you need some legal advice on your specific circumstances as to how good your case is. Because, there's a couple of key facts that could make a real difference. And, no matter what, there's always going to be a risk. That's how litigation goes.
So Ryan, this is probably a good question for you. Can you make employees who choose not to get the vaccine, so they're going to have a vaccinator test policy, can we require them to pay for their own tests?
All right, this becomes down to one of the really tricky questions, and I'm going to.
Yeah, I gave this one to you for a reason.
Yeah, of course.
It's your turn.
I'm just going to leave an asterisk for those of you that are unionized. There may be provisions of the collective agreement that may be relevant to that in terms of what employers are obligated to pay for and not, as far as safety equipment and other things. But assuming that's not a relevant issue, and if there's not a human rights issue, the human rights, the sort of commission and others have taken the public position. If someone actually has a legitimate, creed or disability basis, probably the employer's obligation to pay for it. But I think an employer is fairly well grounded in saying, you want to assert an exemption that, you pay for it. I think an employee who wants to choose that as the big issue they want to take on, they're the ones who are asking for it. They have no particular human rights justification for it. They're being granted an indulgence by the employer. That is probably something that the employer would have a reasonable basis to sustain. That being said, there's always a risk associated with it, and it might actually be, especially if you can get access to low cost or free COVID testing, maybe it's a moot point. I don't know. But I think there is a very legitimate economic, legal basis for an employer to basically say that, it comes sort of down to be not much different than it's outside the human rights context. At the end of the day, this is an indulgence that the employee is arguably not legally entitled to have. So, there may be, it's considered to be their choice in the non-human rights context. So I think the employer has a reasonable argument, and I wouldn't be afraid to take that one on personally.
Yeah. I agree. One question, I think I'll grab this one. Can you implement a mandatory vaccination policy for new employees? And then keep sort of your vaccinator test policy for existing employees to sort of dodge that bullet? I think the answer is yes. As long as both policies address human rights exemptions, there's no reason why you can't. And I've been drafting employment contracts, given the changes, the Bill 27 that came down, which isn't the topic for today, changes to employment agreements. And, in these new employment agreements, one of the things we're asking our clients is, how do you want to deal with COVID? And some employers are telling us that in the application process, they're saying people are being required to disclose their proof of vaccination at that time. In other cases, we're putting these in the employment agreements. But of course, whenever you put something like that into a contract, you always want to expressly say, not just implicitly assume, but expressly say that accommodations are available subject to the human rights requirements, and that people should disclose to you and have no fear of reprisal or that they'll be disadvantaged in any way if they have a valid human rights exemption from such a policy. So Ryan, here's a question that perhaps you can take. So in the event you're implementing a vaccinator test policy, how are people handling the administration of this? So in terms of gathering people's information, keeping track or storing the answers or the documents, the sensitive medical information that people are providing, what advice would you give people who are implementing such a policy?
Yeah, look, I mean, I want to be careful with drawing the line of what I'm an expert on and what I'm not. In terms of questions like this, I mean, certainly what I've seen with clients is that many of them have used their IT department to, use the same sort of methods they currently use to store sensitive information electronically, not put it on a network if it's, that would be disseminated in access to anybody, control access to the controlling access to the information. Some of my clients have have purchased commercially available apps and other such software to keep track of testing. Obviously, the larger you are, the more important that is. Smaller entities have just said, send us a copy of the results, and then we just keep track of them electronically that way. And like a COVID test result looks like, it's just one page. These are mostly antigen tests. The more, the rapid tests you can get straight away. They've just basically had the employees, forward them to them, or in some cases, in some testing sources, have the testing source themselves. It's just as if the employer is paying for it. Typically, the testing source itself will email it directly to someone at the employer. So those are some of the ideas that that have just come up practically with our clients.
Thanks, Ryan. That's good advice, I think. Steady hand is the approach. Here's a question. Can a workplace have different requirements for different people? So in different circumstances, can you have a policy that applies to certain parts of your workforce and certain aspects that apply to others? I think the answer is yes. I don't think you need two different policies, but I think you can have a policy that addresses the different circumstances faced by different workers. So the simplest example would be if you have one group that can work remotely or in the office, and another group that always has to go out to client sites and interact with the public. Certainly, there's an evidence-based way to say that these two groups should be treated differently. And so you're justified in taking greater reasonable precautions in respect of employees who will either be mingling with the public or mingling with vulnerable folks out there, or who cannot work socially distant from their coworkers or from members of the public, versus people who can easily work remotely. You may not have a requirement for them to do any more than disclose their vaccination status to you, so that in the event they do come in, you're aware of what precautions need to be taken. So absolutely, you want a policy that addresses the nuances of your workplace, and that's why just downloading, a vaccination policy you find online isn't necessarily the best way to go. Amending it to tailor to your workplace. And I have to say, without being too self-serving, having your lawyer take a quick look at it is a good idea, to make sure that you're taking the precautions that are reasonable, and that you're not offending any rules, and that it's clear you're going to respect human rights in whatever circumstance. Ryan, what if an employee refuses to disclose their vaccination status? And they decline rapid testing? What can employers do?
Well, I mean, I think at that point, someone who refuses to do that is setting themselves up for a just cause case for termination. That's insubordination. There's no, in my view, that if you are simply refusing to disclose your vaccine status, subsequently refusing to adopt the precautions that are necessary because your vaccine status can't be verified, I think you're likely to be in a situation where you're going to be fired for just cause for insubordination. And in most cases, I think the court would probably uphold that determination. I think on those facts, that's just that is the black letter definition of insubordination.
Yeah, I would agree. I guess good thing to remember whenever we're firing for just cause, we have to make sure we've clearly communicated the requirement. We've warned the employee that if they don't, their job is on the line. And then if they still don't, I think it's assumed, implied in this question, that that's all been done and the person's still refusing. But you have to check those boxes, or else you may end up with a court who isn't as sympathetic as I think they will be if you follow Ryan's advice, and ultimately you fire them, certainly. Here's a question, maybe I'll grab this one. So even if you aren't putting in place a mandatory policy, can you request all employees to provide their vaccination status? I think in general, that is a minimum requirement you can absolutely put in place for everyone. If everyone works remotely, though, and they only ever work remotely, and they're never going, like even pre-COVID, they were working remotely, and you really don't have any nexus to the employment relationship reason to be asking their status, then maybe that would be the unique and only circumstance where maybe you can't ask. I still think there's some good argument there for why you might be able to ask for it, but it may not be just cause for an employee to say, well, why do you need my vaccination status? That's personal, private, confidential information about my medical status that you don't need to know because I work from my basement anyways. But barring that unique circumstance, I think all employers can say, we need to know your status so that we can plan and we can ensure your health and safety and the health and safety of your coworkers. I think the answer in 99.9% of the cases on that will be yes. You can require people to provide you with their vaccination status. Now, Ryan, here's a question for you. So we've got folks who decide not to vaccinate, but they're going to be getting tests. And so what sort of evidence of a negative test should people be accepting or requiring people to provide if they're going to be going with negative test results on a regular basis?
No, I mean, I think this is a pretty straightforward answer, and this is probably, unfortunately, the last question we're going to be able to have time for today. Is that when you get a COVID test, you get a written document that confirms what your whether it's an antigen test or a PCR, you get something in writing that confirms what the results are. If they're being done through a third party, and so that's probably the most that's probably the outcome that you want. If it's a self-administered test, that's a bit of a different story. So you'd want the evidence that as directed in the self-testing kit, but you would want proof either of the actual written document from the provider who's conducting the test, or a photograph or some other evidence from the self-administered test kit.
All right, well, thanks, Ryan. And that is the last question we have time for. There are a number of additional questions, but hopefully if they're being asked by folks who are clients of the firm, we'd be happy for you to call your lawyer, and we'd be happy to help you with those. Otherwise, thanks again for joining us. We had almost 150 people joined online today, so that's fantastic. And everyone stay safe, and we'll see you next time.
Thank you again.